Am I audible to all of you? Okay, 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 okay. Good evening, everyone. On behalf of Team Vidhigyata, I warmly welcome all the participants to the third session of Vidhigyata Civil Drafting course. I hope you find the previous session on legal notice informative and useful. Before we begin, I request everyone to keep their microphone muted. Okay. You may note down your question, which will be addressed at the end of and during the question answer session. In the last session, we have learned about the notice and their drafting process. Today, we will learn about affidavits, one of the most important legal documents used in the court and various legal proceedings. An affidavit is a written statement made under oath and require proper legal drafting and accuracy. To guide us on this important topic, we have with us our mentor for today's session. It is my privilege to introduce Advocate Manas Mishra, sir. He is associated with the High Court of Judicature at Allahabad, Lucknow bench and holds an LLM in criminal law with a minor in human rights from Dr. Hari Singh Gaur Vishwavidyalaya, Sagar. He has authored several research papers and has presented his work at various national and international conferences. Sir, on behalf of Team Vidhigyata and all participants, I extend a very warm welcome and thank you for joining us today. Without taking much of your valuable time, I invite Advocate Manas Mishra sir to conduct today's session on affidavit and drafting exercise. Now, over to you, sir.
Thank you so much, Ashutosh, for having me again, and thank you so much, participants. Uh, Today, I am going to deal one of the most important part of the civil drafting or part of the civil procedure as well. However, it is not relevant for the purpose of uh, uh, drafting to go much in detail. Uh, but I will try to do justice with the topic, not in terms of drafting course, but also in terms of evidence as well as code of civil procedure with relating to affidavit as a whole. So I would request admin to showcase the PPT slide number first. Okay. So far as the meaning or the concept of affidavit is concerned, so as written here, affidavit is a written statement made under oath. The person making it called the deponents declare the facts written in it are true. This is the formal, simple meaning of the affidavit. If we go with the codified definition of affidavit or the most authoritative definition of affidavit, we come across with the section 3, subclause 3 of the General Clauses Act 1897, which defines affidavit as to include affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. The Sorry to have not mentioned this definition here. Uh, by mistake, it was not mentioned. So we will be stressing upon the section 3 subclause 3 of the General Clauses Act as well as the basic concept of the term affidavit. So as I have said that the term affidavit according to the General Clauses Act include affirmation and declaration in the case of person by law allowed to affirm or declare. So it is a matter of higher significance here is to stress upon the term affirmation or declaration or affirmation and declaration. Both these terms seems to be very complementary and supplementary to each other. However, there is a slight difference between the same. Or those who are in drafting process in practical or in their part of in their internship, they might have drafted the affidavit and several times they have come across that saw across the statement that I solemnly affirm or in the name of God. So These two terms are very different. So let us first understand the section 3 of the section 3 sub clause 3 of the General Clauses Act, by one each and every term. So stressing upon the definition, what does it say? It's a voluntary written statement of the facts, that whatsoever facts that have occurred during an incident, accident, or anything that is related to the issue, it is it is resembling the it is resembled as a voluntary written statement. Next is affirmation. Affirmation is a solemn formal declaration that a statement is true according to the knowledge of the deponent, and used by the people who object to taking a religious oath. So here it is very important to understand the religious oath and affirmation. So where it is declared that I, in the name of the God, saying so, and I affirm something so and so. So there is difference between both these things. Those who believe in God, they take oath in the name of the God. Those who do not believe in the God, they generally start saying that I solemnly affirm. जो भगवान में श्रद्धा रखते हैं, आस्था रखते हैं, वो जो है ओथ टर्म यूज करते हैं, और ओथ टर्म जनरली यूज होता है रिलीजियस पर्पस के लिए व्हाइल टेकिंग एनी oath or affirmation. And specifically the term affirmation means it is used by the person who do not believe in God. So there is a slight prima facie it can be seen that they are supplementary and complementary to each other, but there is a basic difference lies between the both. And so far as the declaration term is concerned, so declaration is a very broader term. Declaration can be used for any official statement of fact. There may be or may not be this oath thing or affirmation thing. So here I am done with the definition part or the conceptual part of the affidavit. Now I would like to stress upon this thing that who can administer an oath. Further, also in further slides we will see in detail, but so far as this slide is concerned, so it is written here that it is signed before a person who has legal authority to administer an oath. So according to section 3 of the Indian Oath Act, not Indian Oath Act, it has been repealed. According to section 3 of the Oath Act, notary public, oath commissioner, or magistrate is empowered to administer the oath. And there is one exception also. So normally an affidavit affidavit contains those facts which deponent knows personally or he believes so the same. However, for the purpose of temporary application or interlocutory application, where we are demanding for the interim relief from the court, however, not very concerned with the drafting part, but for the purpose of the code of civil procedure or any matter relating to civil nature that is being tried before the lower court. So temporary applications are the exceptions of affidavit thing, because the opponent may also state that what they believe to be true and what they don't believe to be true. To affirm or to corroborate or to support their statement in affidavit in temporary applications, they must also provide some reasons that why they believe for the same. Please change the slide. Just give me 1 second. Yes. So now coming to the rules under the Code of Civil Procedure 1908. So let us first understand the substantive part of the CPC. And as we have also earlier discussed in a glimpse, and formally by an authoritative term, we are going to discuss here section 139 of the Code of Civil Procedure now 1908, which states that who is authorized to administer affidavit. So it says that any court or magistrate or notary who has been appointed under the Notaries Act 1952, or any officer or other person whom a high court may appoint in this behalf, or any officer appointed by any other court which the state government has generally or specifically empowered in this behalf. So these four things have been given under section 39, who are empowered to authorize, or who are authorized to administer oath for the purpose of affidavit. And now coming to the procedural part, so there are particularly three rules under article 19 specifically, order 19 specifically of the code of civil procedure deals with this affidavit thing. So rule 1 states that for the purpose of this drafting course, rule 1, rule 3, and rule 2 and rule 3 are important. However, there are subsequent rules also, but to understand the concept and to our importance, these three rules must be there while drafting any affidavit. So order 19 rule 1 says that a court may allow a fact to be proved by an affidavit if there is a good reason. So generally, while submitting any evidence before the court, we have to submit an affidavit, or for any document which the law requires to be supported by any affidavit, it is done according to the law, as the law says, or any particular provision of the institute says. So, however, if either party honestly wants to cross-examine the witness, from this statement, as I have said, that a court may allow a fact to be proved by an affidavit if there is good reason. So, there is a question that arises: what is the evidentiary value of the affidavit? Because from this statement, we can infer that what would be the evidentiary value of an affidavit would be of a higher magnitude, or having great probability value. But however, we will look it into detail and discuss the same. However, if either party honestly wants to cross-examine the witness can appear in court. The court should not allow that witness evidence to be given online only through an affidavit. So where the facility of cross-examination is available, so it is required for the witness to appear before the court, and witnesses whatsoever has been claimed as a fact in affidavit is needed to be cross-examined. The example of the same we can see under order 18 rule 4 of the code of civil procedure, where examination in chief is taken on affidavit, and further the law requires that cross-examination and re-examination of the same has to be taken in person. So the court calls witnesses for cross-examination and re-examination for making such evidence having some probability value. Please change the slide. So far as rule 2 is concerned, so it states that either party may give his evidence on affidavit by filing an application to the court. However, the court may order attendance of such witness for his cross-examination, and such attendance is compulsory in court unless he is exempted from personal appearance as provided in the CPC. So the paragraph before, the lines before, unless we have understood the same thing, we can infer as we have read under rule 1 also. But here it is important, he is exempted from the personal appearance as provided in CPC. For example, there may be a case that where by reason of illness or the reason otherwise the witness is not able to come to the court and be available for the cross-examination or re-examination. So court may exempt from his personal appearance. Rule 3, very important for the drafting purpose. Order 18 rule 3, order 19 rule 3 states that affidavit must be confined to the facts that the deponent is able to prove on his belief, except in case of interlocutory application. For the purpose of temporary application or temporary thing that parties demand from the court and they are granted as per the case circumstances and nature of the case. But it is an exception to the affidavit thing. It is not required. and it says that deponent is able to prove. So whatever deponent believes, and if in case he is called for the cross examination or re-examination, he must be able to prove the thing that he has claimed in the affidavit. Otherwise it may lead to some legal consequences that we will deal further. And so it can be said that it is being said here that he must write those facts or claim those facts only that he is able to prove before the court of law where he is being called for the examination or cross examination purpose. Please change the slide. I hope I am able to make you all some sense about the concept of affidavit. Please thumbs up if you are agreeing with me. Now coming to the evidentiary value of affidavit, so it is much debatable topic in our country. However, law of evidence has provided provision for the same, that section 1 subclause 2 of the Bharatiya Sakshya Adhiniam and earlier section 3 of the Indian Evidence Act 1872 states that the act does not apply to affidavits presented to any court or officer. So from the provision of the Indian Evidence Act or the Bharatiya Sakshya Adhiniam, we can infer that affidavit does not have any probative value. So a declaration in the shape of affidavit cannot be received as evidence of the fact stated in it. So we can infer that evidence there is no evidentiary value or weak evidentiary value of the affidavit presented before the court, supporting or corroborating with any evidence presented adduced before the court. It cannot be used as evidence unless the law permits. So it is very important to understand. As I have given the example of order 18 rule 4. So in that case, the examination of chief is done on affidavit, but the witness is being called for the purpose of cross examination and the examination. So here we can ascertain that there may be a case that some probative value affidavit can gain by the way of cross examination and re examination of the same. However, the evidence for the purpose of evidence law, it has been elaborately said that it does not have any probative value or evidentiary value. But in some cases it can be allowed where the law permits for the same, where any specific provision has been mentioned that if something is being recognized or considered and presented before the court, and it has some weight, and it can be adduced supporting the affidavit, so it can be considered as an exception to the section 1 subclause 2 of the Bharatiya Sakshya Adhiniam. However, I am saying that whenever it is asked you anywhere in any exam or interview that what does evidentiary value, what probative value an affidavit carries, so we will be quoting the evidence law section 1 subclause 2. But where it comes to the exception, so where does the law states for any exception, for any proviso that there is if there is provision for taking any evidence on affidavit, we can say that it has some probative value where the cross examination or re-examination have been done, and the same facts as stated in the affidavit are being balanced with the balanced in the cross examination or re-examination. So further moving ahead, the reason is that the deponent of affidavit is not available for the purpose of affidavit not being considered having some evidentiary value or probative value. The reason is clear, written by so many authors like Mullah or Justice M. Munir. He has been Chief Justice of India, so his commentary on the law of evidence states that the deponent of the affidavit is not available because it is made outside the court. So he is not available to be cross-examined in respect of his declaration in the affidavit. So this is the reason why, as per the evidence law, evidentiary value of affidavit is weak or zero or nil. Please change the slide. Let us begin with the drafting of an affidavit. Uh, Before drafting, so far as the theoretical part of the affidavit is concerned, so I would like to request the participants for getting a deeper understanding of this affidavit in terms of section 1 subclause 2 and order 18 rule 4 as well as order 19 of the affidavit. Please refer the book volume 2 of the Mullah's commentary on code of civil procedure. It will give you better understanding, because there are so many there are high courts in our country, and different high courts have different opinion, and for the purpose of drafting affidavit, maybe for the purpose of sage deed or any convincing thing, or this drafting things, there are certain rules framed by the high courts. So we will have to other for the same. Here we will be discussing the general provisions. So let us come on the drafting of affidavit. Following Following rules of general guidance should be taken into account while preparing an affidavit. So far as the first statement is concerned, the person making the affidavit should be clearly identified, containing full name, father's name, and other details such as professional details, what trade he is, and what occupation he is, and what is his residential address. So, for the purpose of identify the person, identify the deponent, his details must be mentioned in the affidavit. Further, as also discussed in detail, that any what amounts to good draft, so good draft amounts to a draft amounts to be good if it is drafted in a very well manner, in a paragraph, in numbered form, and each paragraph should have some meaning, or it should be different. It should have some different facts that has been established or said in the draft form. Next, we have the declaration. Declarant, when he speaks to any fact within his own knowledge, he should use the words "I solemnly affirm." So, as I have already discussed, where this "I solemnly affirm" thing is written, where person does not believe in God, and where or I make oath and say. So where this term is being used, that the person is believing in God and saying that I am well versed with whatever I am going to say in or claim in an affidavit as a fact, or that the deponent solemnly affirms and states and under. So these terms can be used while speaking any facts in the affidavit, that following facts are true to his knowledge, and I solemnly affirm, or I take oath, or I make oath and say in the name of God. So these things should be considered while drafting an affidavit. Please change the slide. Yes. So it should be generally be confined to matters within personal knowledge of the declarant. As I have earlier said, uh, for advancing the purpose of Rule 3 of Order 19, that the person who is claiming something in affidavit as a fact, he should be well aware of the same. He must be personally aware of the same, and he must believe that whatsoever I am going to claim as a fact in the affidavit, I am confident about the same. So you might have come across various draft formats such as sale deed or lease deed or mortgage deed. So while supporting any affidavit, we after beneath affidavit, we are supposed to write a verification also. So this is the purpose of making a verification, that whatsoever is being claimed by the deponent here is true to his knowledge. And in case if he has not if it is not true to his knowledge, or he does not or from where he has got this information, so this thing also be mentioned in the affidavit, that so and so person is there, and I have received this information from so and so person. So, if he verifies a fact on information received, he should make specific mention to this effect. And like I have said, that information received from so and so, which he believes to be true, must also be written in the same. Every person making an affidavit for use in civil court must be properly identified. Like if you are making a news before a notary, before a magistrate, before any person who has been appointed by the high court or authorized by high court to make administer oath, he must personally know you, or he must be known through any other person who knows you. So this identification thing should also be done. Next, we have deponent must be well versed with the content of the affidavit before administering oath or affirmation. In case where in the person who is administering the oath must also ask that whether the person making the affidavit has read the affidavit or not, whether he is well aware of the fact that has been mentioned in the affidavit, he is well aware of the not well versed or not. So this thing also be considered while an affidavit is being adduced. So if he is unable to read or he has not read the content, it is a duty of the officer to make him read but personally, or he must appoint some other person to make the person understand whatsoever content had been written in the affidavit. Next, the officer must certify at the bottom of the affidavit that it was made before him. So wherever there is a sign of the deponent, having identified the person who is making the affidavit must also write his name and sign that the person who is administrating the oath, he also knows the person personally or by way of any other person who knows the deponent personally. Next, and at the last, there date should be mentioned, time should be mentioned, and place where the affidavit has been made should also be mentioned. And any other document, if any document are referred to in the affidavit, the officer must mark it as exhibit, and it should be kept for the identification purpose. Please change the slide. Yes. In any clerical or typing mistake, if there is any clerical mistake or typing mistake that has been occurred and it is being corrected in the affidavit, the officer before whom the affidavit is made must put his initials next to the correction. That whatsoever correction has been made must be clearly mentioning, must be clearly written in some correction form by the officer. Once an affidavit has been sworn, its contents cannot be changed. It has been sworn, it has been taken on oath or solemnly affirmed, and notary has signed, notary has provided all the things that was required for the execution of that something which is being supported by the affidavit along with the affidavit. So further, if there is any something is left, it cannot be corrected or changed in the same draft. However, we can go for the supplementary affidavit. We can file another affidavit only with the permission or leave of the court. Permission or leave, same thing. That if the court permits for the same, we can file a supplementary affidavit for the purpose. So every affidavit, we are dealing the last point. Every affidavit should end with the following oath or affirmation that. I swear or solemnly affirm. When I am taking the term I swear, so it is being made by the person who believes in God. And if he is solemnly affirmed, he does not believe in God, that this declaration is true, that the contents of this affidavit are true, and nothing material has been concealed, and there that no part of it is false. Remember that whenever this statement is made, it carries a very high value. Because in case you have claimed something or concealing something, stating that you are not concealing, it may lead to committing of an offense under which can be you and the deponent can be charged under a particular section of the Bharatiya Nyaya Sanhita. We will be discussing at last that thing also. There is also some confusion many authors have written in their book that which provisions should be applicable. There are difference between two provisions and conflict between two provisions also. So we will be discussing the same at later stage. Please change the slide. Yes. Let us discuss the content of an affidavit. So an affidavit mainly consists of the following parts. Uh, First is the cause title, description of the deponent, auth or affirmation by whom it has been taken. So far we have discussed statement of facts, that we say recitals, verification of the deponent, that advancing the rule 3 of the order 19 verification thing, and identification of the deponent by the person or officer before whom the affidavit has been affirmed, and certification of verification by the officer before whom the affidavit is sought. So these are the content of the or parts of the affidavit that an affidavit must have. Please change the slide. One by one we will be discussing. Yes, let us understand or analyze the parts of the affidavit. First is the cause title. So as written here, every affidavit should mention the name of the court or authority before which it is filed. So as we can see, it is for the purpose, it is not for the purpose of affidavit. However, some things should be mentioned, but it is for the drafting affidavit as a whole, because they, as per the nature case, what does the Oath Act provides, that there are certain formats that has been given in a schedule at last, that what should be proper statement line that should be used before making an affidavit during drafting process. So it, like cause title, I am dealing here, for example, that any evidence has been adduced and it is being supported by an affidavit. So cause title is important where where any affidavit is filed before the court or for judicial process. So the court's name must be mentioned, like in the court or before the court, and mentioning the designation of authority against whom this affidavit thing is being adduced. So if the affidavit relates to any existing case, the title and case number should also be mentioned, that A versus B in the matter of A versus B, and whatsoever the case numbers but a particular case carries, it should also be mentioned. If there is no pending case, pendente light thing, if there is no pendente light thing, then it should be titled that in the matter of so and so, like I have said, in the matter of A and B should be mentioned. Next slide, please. Yes, let us discuss the description of the deponent. Very important for the purpose of our drafting course as well and as a whole also. So, as discussed earlier, that full name, address, father's name, religion, profession, the person is a trade in, he is in, or the occupation being carried, occupation the person is in, and the permanent address as well as the present address must be mentioned for the purpose of identifying the deponent. So this is the first thing that description of the deponent carries, so it should be properly mentioned. For example, we can see here that affidavit of Mr. A and B, who is all known with any nickname also. He is aged of 35 years and he is son of Mr. E and F. He is Hindu by religion and residence of from this place and presently residing at some other place. So it should also be mentioned. In case the residence is same, there is no need to repeat the same thing. We can write one address as well. So for the purpose of identification, all these details must be mentioned in an affidavit. Please change the slide. Oath or affirmation. We have dealt in detail with the difference between oath and affirmation. So it should also be mentioned properly as a statement that the above named deponent do hereby swear or solemnly affirm as follows. Then we will start the writing process or a statement of that thing. Please change the slide. Give me 1 second. Yes. So let us discuss the statement of facts. So far as the first paragraph is concerned, so deponent must identify that what status it is being carried out by the deponent. For example, whether he is deplaintiff, whether he is petitioner or respondent or defendant or applicant or opposite party or attorney or paraquar, it must be mentioned. It should also state that the deponent knows the fact of the case. Initially, we can also mention that that I am the plaintiff or defendant or so and so in the above case, and am fully acquainted with the facts stated below. That's the sole purpose of the affidavit, objective of the affidavit, that any person who is filing before the court or before any convincing document like sale deed, mortgage deed, that he is well versed with the facts whatsoever matter has been there, be it in, if we are talking about any sale or mortgage thing, so he is well aware about the parties, he is well aware about the consideration thing or any other detail relating to the matter. So this thing, the first paragraph should contain this thing, that what is the capacity of the person who is making an affidavit, and it should be written as given in the example below. Please change the slide. Subsequent paragraphs, yes, there may be there are subsequent paragraphs having so many facts relating to the affidavit, relating to the matter is that is being supported with an affidavit. So every paragraph should be written in separate paragraphs, and each paragraph should be numbered consecutively, 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 and it should be like I have already dealt with the same in the legal notice part also, and here as well, discussed a few minutes ago, that it should be numbered and properly written in a paragraph. Separate paragraphs should be there, and separate facts must be mentioned in separate paragraphs. Each paragraph should deal with only one fact or one subject as far as possible. Next, we have counter affidavit or rejoinder affidavit. For example, you are not dealing with affidavit thing. This I am telling for the purpose of code of civil procedure, where plaint has been filed and you are supposed to file written statement. So you have to file the counter affidavit or any kind of rejoinder affidavit is being filed for any other purpose. So you must, for the deponent should first state that he has read, or it has been read and explained to him, the affidavit filed by the opposite party. In this case, for the purpose of counter affidavit, uh, he is acting, or the status of the person who is filing an affidavit termed as counter affidavit is the opposite party, and he should also state that he has understood its content, that he is well aware of the fact that he is mentioning, and thereafter he should reply to each paragraph of the opposite party, the party that anything that he has received, and him while filing in counter affidavit, he must reply to each paragraph of the opposite party one by one, claiming rejecting or accepting his statement one by one in the affidavit. Please change the slide. Facts must be clearly stated as discussed above. That it should be true to his knowledge, but he is true to his personal knowledge. In case where he is the second party or second person to be known, so he must write the primary person from whom he has ascertained the knowledge. So his acquaintances should also be mentioned in the affidavit. The affidavit should be written in the first person using I, that not using the term we. It is a first person document, so it should be written as like this. No opinion on legal argument. Affidavit does not contain any kind of opinion that you believe. So, or any legal person, you are claiming any fact that you believe, but you are not supposed to give any sort of opinion that in my opinion or in my terms. This is not the fact. Whatsoever you know and you believe that whatsoever I know is true to my knowledge is true fact, and nobody can. And I am enough in the position that whensoever I am being called for the examination, cross examination purpose or re-examination purpose, I am in the position that I will be able to making the sense before the court of law. So there is no place for this opinion or legal argument also, that you are not supposed to argue anything, like those who are in the process of writing research papers or other things, that as a researcher we argue the things that in my opinion this can, like there may be many kind of research, but so far as the particular doctrinal study that we follow in our law legal studies, we argue the things that if I have some opinion regarding section 363 of the Indian Evidence Act dealing with electronic evidence, pertaining and its connection or with reference to artificial use of artificial intelligence in the court. So I have this particular statement because the law has not addressed the thing. The law has not addressed any particular issue that I am dealing with. So the case here is vice versa. You are not supposed to give any legal argument in the affidavit or the pure questions of law. You are not supposed to deal with the same. You will have to confine and cabin yourself to the facts only. You are supposed to deal with the facts that you believe to be true, not the otherwise thing you are supposed to mention. Next is personal knowledge. So normally an affidavit should contain only those facts which deponent personally knows and can prove if called for the cross examination or re-examination. So many things, so many times I have already delivered. Please change the slide. Yes. Earlier discussed also that information received from others should be mentioned. So in interlocutory proceedings, if a fact is not within the deponent's personal knowledge, so he must state that I am informed, that the statement prima facie states that he has been informed by some other person or some other sources. So as written here, I am informed. It is not in the case that he is well aware of the fact, but he is referring the source which he has from he has got some fact knowledge of the facts. So it should be mentioned, and he must mention the name, the address of the person who has given him the information, and sufficient details to identify that person should also be mentioned. Facts based on the documents. If facts are based on the documents obtained from a court or any other source, so what would be the case? The deponent should mention the source of the document, and he should also state that he believes those facts to be true. So this source thing should be disclosed, and correct description thing. So every place mentioned in the affidavit should be correctly described in the affidavit. So as discussed earlier, for the purpose of identification, correct name, correct address, and other necessary details should be mentioned clearly in an affidavit. Please change the slide. Yes, at last, and advancing the provision as already discussed, the rule 3 of the order 19, verification things should be mentioned, that after stating all the facts that it is required and it is a duty of the deponent to verify the affidavit. In so many case law, and last week also, I am not able to remember a case. There was a ruling from the Supreme Court of India that any affidavit without any verification will not be entertained. So affidavit uh, must always be supported with the verification thing. So usually we can encounter in any convincing document that there is application or there is drafting of any affidavit, any sales deed or lease deed, then we come across with the affidavit thing, and then at last we are supposed to write the verification. So these are the three important discussions that we are supposed to do in any drafting of any convincing document. And he should also state the yes. So what we do in a verification is that whatsoever paragraphs that has been mentioned in the affidavit are true to his knowledge or true to his personal knowledge. and which paragraphs are based on the some other sources should be disclosed in verification thing, and any sort of material thing that is required to be mentioned in the affidavit should not be concealed. For example, let us read this. I, above named opponent, Mr. X, maybe, do hereby swear or solemnly affirm that we understand the slight difference between both, that the contents of paragraphs 1 to 5 are true to my knowledge, and paragraphs 6 to 8 are based on some other information that is received, but it has been received, but he believes so. He believes on the information that has been mentioned in paragraph 6 to 8, and nothing material has been concealed in the affidavit. So this should be mentioned. And at last of the verification, the place of verification and date of verification should be clearly mentioned to properly serve the purpose of serve the purpose of attaching any affidavit along with the verification, to serve the purpose of any sales deed, lease deed, mortgage deed, or any kind of deed that we are dealing with, and the law requires to be supported by affidavit followed by verification. Please change the slide. Yes, very important thing that I am not that authoritative person to write something, but having researched on the topic, I have come across that several authors have maybe wrongly mentioned, and what particular, maybe we can, if any book comes, like if we look into the KD Gaure's in Bharatiya Nyaya Sanhita, this thing has been clearly mentioned, or the slight difference between section 216 and section 227 of the BNS has been made, but there are several drafting books that students usually refer, and I believe that many several wrong information relating to the offense that is being committed, claiming a false fact in an affidavit has been mentioned. So I would request a student to correct, verify the information that I am also being delivering here. But I have come across 2 3 books, and then I am coming to this conclusion that. Uh, any person who has committed an offense, if he knowingly lie after making an oath or affirmation before a public servant when they are legally required to tell the truth. So, for example, you have, like already I have discussed that the person, the deponents must claim those things which should be true to his knowledge, and he has been taken on oath or affirmation before the public servant, like for example a judicial magistrate or judge is a public servant if he is taking any affidavit, or any person who is authorized by the high court is for serving the purpose of the section 3 of the oath act, and for the purpose of code of section 139 of the civil procedure code. Any person who has been appointed for administrating the oath or affirmation will be considered as a public servant, and because he may be a private person, he may be not a gazetted officer, but as he is performing a public function, he would be considered as a public servant. So, in case you are claiming, if in case a dependent is claiming any false statement on oath, it is an offense under 216 of the Bharatiya Nyaya Sanhita 2023. So, for fulfilling the requirements of this section, it must be proved that the person took an oath or affirmation that whatsoever he is claiming as a fact in the affidavit is true to his knowledge, or he believes for the same if any information that has been received by any other person which he believes firmly to be true. Next, the person was legally bound to speak the truth before public servant. He was legally bound to speak the truth or claim the true thing in the affidavit, but he has not done so, and then he has been charged later at a later stage in any litigation. It has been found that false statement has been claimed by the deponent, and that false statement has been taken on oath or affirmation. And what was the duty? The duty was to speak the truth before the public servant, because it carries a higher weight and higher magnitude. Next is that the person made a statement about matter is being considered, that any sort of statement that he does not believe to be true, but he has affirmed that he believes to be true, and it has been made as a statement in any matter that has been considered. Maybe for the execution of a sale deed, you have gone to the sub registrar, and you have claimed that at later stage it is found that you have concealed a statement. So it would also be case that the sale deed may be rejected at later stage. For example, there might, like those who have studied transfer of property act, there may be case that there may be interest of any other person also, and two persons have come across to deal with the sales of any land, and sales deed has been executed, and later it is found that there has been any other person also whose interest lies, and while execution during the execution thing or in the affidavit, deponent has claimed that there are two persons only, or the interest lie the following persons, the interest of the following persons had lied. So at later stage it can be found, if it is found, then it would lead to very serious offense and very serious punishment also. So and the last requirement of this section is that the statement was false and the person knew it was false, still he has claimed that he believes it to be true. Please change the slide. Now we will see the difference between 216 and 227. Earlier, section 118 of the Indian Penal Code was dealing with 216, but uh, several authors have mentioned that in case you are making any statement of false statement on oath, it will be dealt under section 290 and 293 of the, and its punishment has been given under the 293 of the Indian Penal Code. However, while reading the statute, as a prudence man, you can find out the difference between things. What does the section 216 is dealing with? It is dealing with the any statement that is being any false statement that has been made on oath or solemnly affirmed the same. But section 227 or section 290 deals with the giving false evidence. And like we have already studied or having some glimpse on or stressing upon the section 1 or subclause 2 of the Indian section 3 of the Indian Evidence Act, or section 1 subclause 2 of the Bharatiya Sakshi Adhiniam, we have come across that affidavit is not considered as a evidence. So for the purpose of making an affidavit which do not lead to any evidence at initial stage, as there may be there may be procedure. For example, if you are talking about the uh, rule 6 of the order 11, as I can remember, all the rule 4 of the order 18, for the purpose of rule 4 order 18 as well, various evidence are filed on the affidavit. So in case it is affidavit not leading to any evidence, the applicable section would be section 216, which is of lesser degree. How, while section 227 will be attracted where any statement that has been made on which is leading to any evidence. So section 227 of the Bharatiya Sakshi Niyam will be attracted here. So simply we can say here, like prima facie, we can see that section 216 and 227 are very similar, as they are making the false statement on oath. The difference is how serious the false statement is, it is, or not the nature of the act. Whether it is just an statement that has been oath or administered and it was a false evidence, or this the statement is leading to any evidence, where we are deciding the evidentiary value or probative value of something when it is cross-examined or re-examined, as we see in the rule according to the rule 4 or rule 4 of the order 18. So section 216, as I have said, when a person knowingly makes a false statement on oath or affirmation to public servant, the maximum punishment is 3 years imprisonment along with the fine. And if that false statement is leading to giving any false evidence as well, under section, it will be dealt under section 227, and it has higher punishment of 7 years. So it can be concluded that every false statement may involve a false, every false evidence may involve a false statement, but it will not be the case again and again that every false statement become a false evidence. So false evidence is considered as a means any statement that is leading to false evidence as well. It is considered as a more serious offense because it is capable of affecting any judicial proceeding. It may not be for the purpose of any convincing document until unless it is not brought in the judicial process. For example, the in it, that later states that something is being found, and so it will be the statement will remain same if something is found fishy in sales deed or mortgage deed, until unless it is not leading to any evidence that we can come across with the various provisions like section 74 of the Bharatiya Sakshi Nidhim that specifically deals with this sales deed or any other deed thing, the proof or admissibility of these things, so that we can discuss in detail. But for the purpose of understanding the drafting of affidavit is concerned, so the important section of much significant provision of much significance here for our purpose is section 216, that if you have made the deponent has made any false statement, it will be dealt under section 216 of the Bharatiya Nyaya Sanhita, not under section 227. And the difference is very thin line, very clear, that until unless the statement does not lead with the making of or fabricating or leading to any false evidence also, section 216 will be applicable. Otherwise, section 227 will be applicable. So thank you so much. This was from my part, and I hope there is no more PPTs or slides.
There is, just a minute.
Is there any more slide, or it was the end of the PPT?
Sir, there is a format, drafting format. So
Okay.
I would request you to please just.
Okay. Like we have discussed so many things while making a PPT. This time I have tried to write down those things that are important for the purpose of drafting as well. So for the purpose, let us see an example. I will not be deliberating the same thing that I have already stressed upon or delivered while doing the theoretic, while dealing with the theoretical aspect. So let us have a glimpse on the same. So like I have like while dealing with the content of affidavit, the first thing that we have encountered is the cause title. So it has been written here that in the court of district judge district district jo bhi hai, Delhi, and suit number. So if it is written here suit number of the year, any particular year, so it means that the matter is pendente light. Sorry, pendente light is something different. Matter is sub judice before the court. So suit under order 38 of the Code of Civil Procedure. Okay. Next is in the matter of Miss ABC Private Limited, and his address has been mentioned, and he serves as the status of the party. The first party is plaintiff versus the Mr. XY, Majors XYZ, whose status is defendant. Next is now statement of facts or recital things we can come across, that it is the statement made by Mr. So and so, and he is the son of Mr. So and so, who is aged about 30 years, and he resides at a particular in the capacity of director Majors ABC Private ABC Private Limited. So it should be properly mentioned here by whom this affidavit is being adduced. Next, we can say that as already discussed that we do not use any other pronoun, like it is a first person document, so I word is used, and following was statement 1, 2, 3 are the statement of facts, and later it will be signed by the deponent. And so many complexities or so many things that I have discussed will be of the much importance, where we are dealing in detailed things with the civil procedure code. So it will have some like statement of purpose, then whatsoever information has been received by another person or other or he is believing to be true. So these you can encounter in as per the nature of the case, as per the facts of the case. So it can be certain also that in 3 paragraphs we have compiled that this is the statement of fact, then it will be signed by the deponent, and it will be further attached by the verification advancing rule theory of the order 18. So please scroll down. And it will be again signed by the deponent that he is verifying the above mentioned statement on the date at Delhi, and the contents of the said affidavit are true to his knowledge, and nothing material has been concealed therefrom. So we can understand from the affidavit, and you can encounter so many affidavits according to the each affidavit. Like there are certain formats that courts generally issue, that any particular form should be in that any particular affidavit relating to any particular provision or matter in issue should be in that form. So we will have to generally look for those rules also, and there are conventional rules framed by the high court or that is in convention being followed as a practice, so that should also be described here. Whatsoever we have discussed, these are the general things that we can find out as per the nature of the case, as per the facts of the case. So that was all from my part. Thank you so much for listening me and having me here. So thank you so much.
Thank you so much, sir, for your such an insightful and practical session. Your guidance and on the concept, structure, and drafting of affidavits has been extremely valuable for all participation. We sincerely appreciate your time and expertise. We shall now proceed to the question and answer session. Participant may raise their hand or post their question in chat box. If anyone has any questions, then he can post their question in the chat box.
uh,
Please
so
inbox
far
for any queries.
able to ascertain any query, but there has been constant request from the students who are having Hindi background. So what we can do for those students, that we can provide material for them, and we can provide this we can arrange any other session for those students as well, if the team agrees, or as per the demand of the Vidhigyata. So I don't have any issue, since the large number of students having understanding, having the language being understood by them is English. So I will have to, I have to do the deliberation in English only. So I'm sorry for that as well. You can take, I am writing my email. If you have any query, then you can also post me on the same. And for sure, I will reply to
Is
it.
there any question? Is there any question? Please put their question on chat box. Otherwise, we will proceed further.
As I can say, there is a question on 1 minute. Yes, let me just explain the difference between verification and affidavit is concerned. So, in affidavit, we are claiming the statement that we believe to be true in my knowledge. Verification is supported by affidavit, or we can say that anything relating to matter in issue and those facts have been claimed as true to the knowledge of the deponent, and it is further being verified in the verification. Like I have said that the above statements, like we are separately dealing with the facts in the affidavit, but we are not going into detail while drafting a verification, and we are just saying that these like if we elaborate that if there is information that has been received from some other source and the deponent has been informed for the same, but he does not believe to be true as a primary person, so that thing will be mentioned in the verification thing, and like in subsequent paragraphs, and those paragraphs which he personally believes to be true has to be mentioned separately. And at last we have to mention that nothing material has been concealed. It is also one kind of oath or affirmation that you are making that any sort of concealment has not taken place in the affidavit or relating to the matter in issue. That is the basic difference between, we can say, in the verification and affidavit. Uh, Under the general rule against so far as the admissibility of hearsay evidence is concerned, however, not very much significance for our discussion also. But there are n number of case laws dealing with the hearsay evidence, and in crux we can say, or that we have come across, that hearsay evidence does not have any probative value. It does not have any evidentiary value to deal with it. So it is usually criticized before the court of law. In any, and hearsay can be of any matter whatsoever being has been brought before the court. There is no place for the hearsay evidence in the statute as well as before the court of law during the procedure or trial, or the matter when it is being taken on evidence. If then affidavit contains a false statement due to liar's drafting error rather than client's intended to lie, what will be its after process in court? Very important issue has been highlighted here by Mr. Vishwendra Pratap Singh. So I would be clarifying this issue, but I would request you to please go through the Order 19 of Code of Civil Procedure um, from the book of Code of Mulla's Commentary on Code of Civil Procedure, Volume 2. It is a reference book, not a student edition. There is a very long history about the same that the doubt you have asked. Actually, if we are dealing with the law relating to the if we are dealing with the law relating to the affidavit, if we are going to the theoretical aspect of the affidavit, so it has been brought by, and there were certain amendments that are relating to Commercial Codes Act 2020 2015, and actually, and Mr. Mullah has elaborately discussed this doubt that in case where this we can say it is the flaw of the law, that earlier it was serving the purpose of the it may serve the purpose of the serve the purpose of the lawyer but not the client. For example, there has been any issue relating to where the money thing has been involved. And in case that money, the lawyer does not mention that how much consideration was, or the what would be the pecuniary, what is the pecuniary value of the same. So in case it has not been mentioned that the issue relating to the same involves the amount of rupees 40,000 or 50,000, and it has been not properly mentioned that it has not been properly mentioned कि amount mention नहीं किया गया, और लिख दिया गया कि this is the matter and money thing is involved, but how much money thing has been involved, it has not been discussed anywhere in the drafting. And it will also be, it has been long practice in India. If we go to the commentary that I am saying you to read, you can properly understand the thing. And usually in practical sense, today it is not being practiced. We can say that lawyers are well versed of the drafting part, lawyer as well as the person before whom we are going. For example, maybe notary does not take care of the same, but if it is being for the purpose of evidence we are talking, if it is being adduced before the court or any other person, like for example section 3 of the notary oath act or the code of civil procedure 139 requires those persons to be administrative to be officers to have administered administer oath or affirmation. Then they will be highlighting the same issue also, that why the amount has not been mentioned. So it earlier it you can say it was error, but it has, there was a long practice that certain errors have been it was being done intentionally, not by error also. So I would like to request you that please refer to that document. It will give you much deeper understanding about this thing. And very important issue you have
Thank you so
highlighted. Very okay. Thank you so much, Mr. Admin. I have taken so much time today.
thank you.
So I'm
No, no,
sorry for
no,
this.
no, sir. Sorry to interrupt you. Thank you so much, sir. There is a notice for all the participants. It has been observed that many participants are repeatedly asking where and how to submit their task, despite the fact that detailed instruction have already been provided in the task PDF. Please note that all participants have been divided into 5 groups, and the name and email address of your respective group head have already been mentioned in the PDF. You are required to submit your task only to your assigned group head through the provided email address. Before raising query, kindly read the instructions carefully. Most of the questions being asked have already been answered in the document shared with you. Repeatedly asking question without reading the provided instruction create unnecessary confusion and delay the process for everyone. Therefore, all participants are requested to carefully go through the task PDF and follow the submission guideline accordingly. Okay, so now, thank you everyone for your active participation and thoughtful queries. As we come to the end of today's session, I would like to express my heartfelt gratitude to Advocate Manas Mishra sir for sharing his valuable knowledge and practical insight with us. I would also like to thank all the participants for their enthusiastic participation and continued support. The recording of today's session will be uploaded on the official VIDHIGYATA YouTube channel. Stay connected with the VIDHIGYATA for updates regarding upcoming session and opportunity. Thank you everyone for joining us. Thank you so much. Thank you so much, Manas sir, once again for this insightful session. Now participants may leave the session.